If that's going on, big if, okay? If that's what's going on, that's different than tit for tat, that's different than the strategic misuse of discipline, that's a serious problem that should be taken into account. So that's, I think, that what the other side is saying, the most serious case for the other side here, is we have to at least investigate and figure out whether that's what went on. If it's not, okay. But that's at least the possibility we should be looking into.
All right, next question.
My name is Gerald Walpin. The my question I want to pose is to Professor Wendel. The examples and facts to which you have applied the rule of law have been current, emotional, and politicized issues. I'd like to ask you how you would apply your principle of rule of law to some other issue which goes back some time and on which I would hazard a guess all people in this room are unanimous that the law at that time was incorrect. Let us take the issue between the time of Plessy v. Ferguson and Brown v. Board of Education. And you had, before there was any court decisions stating that separate but equal was unconstitutional. And you had a lawyer advise his black clients in the South that he believes the Constitution makes the separate but equal unconstitutional. And he advises his clients to go into the school and attempt to register. And he is met with National Guard, policemen, and the result of it is a riot which involves the unfortunate death of one of the children. Could the state prosecute, under your rule of law, as I understand it, that lawyer for going against the rule, what was the law, inducing a riot which resulted in a death?
Of course that lawyer would have acted unethically in the same terms that I'm setting out here. Absolutely. That lawyer could be sued by his or her clients for malpractice. That lawyer could be disciplined, of course. That's not a hard case. The lawyer could advise the client to set up a test case, to engage in civil disobedience, to participate in some kind of legal strategy for reform. That would be fine. But if the lawyer in the early, post-Plessy era, before there were any litigated decisions establishing that there were, cracks in the armor, if that lawyer said straightforwardly separate but equal is unconstitutional, that would be incorrect legal advice, and that would be subject to discipline in exactly the same way as I'm talking about here. I mean, I'm a legal positivist. I believe that, as Mr. Estrada said, I believe the law means something, and at the time the law meant something. It was morally wrong, but it meant something, and to the extent a lawyer purports to be giving legal advice, that would have been the incorrect legal advice, and of course the lawyer would be subject to discipline.
Really?
Yes.
I actually thought not to take over your side of the argument, but I thought that your argument was going to be that would be appropriate legal advice if you had all the caveats as to how the controlling law currently said that this is not an available claim, but that you're doing this in the hopes that you can sort of show that your case is different or that there is some other factor that applies. Wow.
No, that is what I said. I said, if the caveats were there, no, if the lawyer advised the client appropriately and gave the caveats and said, if you want to be a test case, you want to go first, go for it. I mean, that's fine. So with the appropriate caveats, that advice could be given.
Next question.
Hello, this is for either speaker. Is there a point where moral advice can begin to encroach on a lawyer's duty to provide competent advice and to act as a zealous advocate? And I guess another way to phrase that question would be, I know that a lawyer may provide ethical or moral advice, but is there an expectation that he will? And if so, should there be that expectation?
Professor,
I keep getting all the questions. It seems unfair.
Look at the venue.
Yeah. Go figure. I'm fair and balanced, right? Well, no, I think, not to be too inside baseball here, but one of the things that I do in the legal ethics world is try to argue against people who believe that professional responsibility is about following ordinary morality straightforwardly, and doing the right thing. And I catch a lot of flack for saying, no, legal ethics is not about doing the right thing in that kind of general sense, but it's about respecting the justified obligations of one's political role. So, if a lawyer believes for moral reasons that it's impossible to carry out her obligations as a lawyer, then she has to resign, not represent the client, or something like that. I resist, and some of my fellow travelers in the legal ethics world on the left want to slant legal advice to make the right the quote, right, moral analysis also legal. And I resist that. I mean, I argue against that kind of too pat conflation of what we take to be the right thing with what is the lawful thing. That's why I gave the answer I did to the Brown question. It may be the case that a lawyer says, this is morally a rotten thing to do. I object to it. I think it's terrible, but you're legally entitled to do it, and I will assist you in doing it. Now, if the disagreement becomes so severe that the lawyer can't be an effective representative, then there's a personal interest conflict, and the lawyer has to withdraw from the representation. But no, I don't think moral advice should slant legal advising. It's difficult in some cases, but as lawyers, we have a hard job, and sometimes one of the things we have to resist is the belief that what our client is doing is kind of crummy. That's not really relevant to the interpretation and application of the law.
All right, next question.
I guess I'll preface this question by noting that I strongly disagree with many of the things that were said in those OLC memos, so that the intent of the question would not be misconstrued. Nonetheless, it seems to me that I was a bit surprised that both sides seem to agree that the proper standards for this should basically be the same as those that apply to private sector lawyers, and it seems to me that there's at least one major distinction between the two situations, and that is when you have government lawyers in OLC and other similar positions, you're often dealing with issues where there's deep and fundamental disagreements that are motivated at least in part by politics and ideology. I teach constitutional law, and all the time in constitutional law, there are major controversies where the two sides disagree not only over what the outcome of a case should be, but even fundamentally over what the methodology for approaching the question should be. The international law issues that were mentioned in the panel are an example of this. I was wondering, is there not a case for treating the situation at least somewhat differently than a private law situation, given that it's very easy to say, well, if you're not an originalist about constitutional interpretation, that means you're taking totally the wrong approach to analyzing the issues, or contrary-wise, if you are not a living constitutionalist, you're taking totally the wrong approach, and the same if you believe that international law should or should not be used to supersede domestic law with respect to some of these war and terror situations.
Should I start? I mean, I think we have to sort of parse very finely here. I mean, for many years, the rules of the several bars were claimed to apply to government lawyers somewhat over the objection of the federal government. It happened in the 1980s and the 1990s that a trend developed, and this came especially out of the criminal defense bar, where every criminal procedure fight that the criminal defense bar lost in the Supreme Court of the United States, whether you could sort of interrogate, the defendant, and whether you had to tell him this, whether you had to serve a subpoena, or whether you could serve a subpoena on a defense counsel, and whether there was anything in the Constitution that kept a prosecutor, for example, from doing that, then it became an ethics complaint. And the way that this worked out is that people in the Justice Department, and Attorney General Reno was at the front of this, were somewhat concerned that the ethical rules were being used as a weapon to impinge on uniquely federal interests. And as a result of that, she promulgated a regulation that basically tried to say, under her authority of Attorney General, that she was coming up with a set of rules as to when it was appropriate to apply this, that, or the other rule. In a case called McDonnell Douglas in the 1990s, the Eighth Circuit tossed us out as being bereft of any actual authority. And that got conjoined shortly thereafter with the prosecution of a congressman by the name of McDade, who was on the receiving end of the V in a criminal indictment, managed to get acquitted and was too happy about it. And as a result of that, since he believed that his prosecutors had been unethical in bringing this prosecution, he saw to it that there is now a federal statute that says that the prosecutors have to comply with the ethical rules generally of the state of licensure.